Hello?
Can you hear me?
Yeah.
Cool.
Remember last time your audio was really good and then you went off your audio. And then
Yeah, exactly. So I'm using my better headphones.
Okay.
And so they should last the whole time.
Do you have a podcast mic?
I do not.
All right. Well, it might be worth getting one, or we might have one at the office, extra one that you can use. Okay. Remind me, because that might be helpful too.
Okay.
It's like, I don't know if you can tell. Is there a difference? Am I using mine? I don't even know if I'm using mine. I have it plugged in. Can you hear this? Looks like this.
I don't notice a difference.
I wonder if I plug it out. Do you notice a difference now? Is there a difference now? I don't know if this is even activated or how to activate it. Yeah. Okay. So, and then I think we want to make sure that we're telling people to mute their mics, and then with Stephen to give you like the speaker view. We can do gallery view, we can do speaker view, which means who's ever making a noise trumps that thing. So that's why I think if Marquise had his mic live the whole time.
Yeah.
Or just maybe tell him to go back and forth between gallery and speaker, and maybe be mindful of that.
So let me. Oh, I need screen sharing.
Okay, I'll make you a co-host. Do you want to add Sussman and Shank to your name?
Sure. That would be fine.
Do you know how to do that? You just rename your thing. I don't know if it would show up like that, but it might. Yeah, you wouldn't be able to see all of it, so maybe it's not necessary. I can try. Hold on. Sussman, S-U-S-Men, and the and symbol.
No and.
Sussman Shank LLP.
No, I got it.
I just did it. But yeah, it doesn't all show up, but unless you, well, yeah, it does. If people, put their cursor over you.
Let me add it.
Okay. All right. Is that the new thing you wanted to sign? Was your headphones?
Do I? No. I want to try the. I'm actually doing the presentation on my virtual desktop, so I want to make sure that works. All right. Can you see it?
Mm-hmm. I can still see the outline though. Is that supposed to be that way? Like where you have options, connect USB? Did you want that?
Oh, okay. Yep. No, I don't. That's the key thing. All right.
Go to options once.
So let's try it. Okay, what about now?
Nope. Yeah, that's good. That looks good.
All right. Well, that was a failure.
What was a failure? Were you trying to do it the other way?
Yeah, because the way I'm doing it now, I've got to like email it to myself, and there's a lot of like digital shuffling going around. I wanted to see if I could avoid.
Okay. Stephen should be coming here shortly. Did you have a good weekend?
Yeah, I
How was
did.
it? What'd you do?
Played a lot of video games, did some wedding stuff, uh, found a new book, did some house cleaning, took the dogs to the dog park.
Nice. Productive. What was the book?
It is a book on competition, but it's written by two race car team owners.
On
And they
competition?
use, yeah, competition and kind of sports team management. And they use their Formula One experience to sort of frame everything. So the two framing devices are the Art of War and uh, one of the guys' Formula One experience.
Oh, do they talk about, I don't know, is there such thing as healthy competition versus unhealthy
Oh yeah,
competition?
yeah,
That's what they talk about?
yeah. That's part of it. And one of the things that was touched on um, was the uh, yeah, unhealthy practices, especially with people management and effective people management, um, inspiring your people to do well, that kind of thing.
Oh yeah, I want to read that. Competition, huh? That's what it's called.
Uh, what is it called? I mean, something.
Did somebody recommend it to you?
No, I was just looking through Audible for a new book, Total Competition,
Total
Ross
competition.
Braun and Adam Parr.
Adam Parr and Ross Brown.
Hmm.
That's not the one they made that movie about, was it?
Nope, I don't think so. It's pretty recent. It's like 2017.
The one that Thor was in, remember? That Formula One?
No, that's the same league, but no, that's I think that was a different book, like Rush of something was the book, and then the movie was just Rush.
Oh yeah, Rush. That's right. Right.
I saw that book came up when I was looking
Mm.
and found the one I'm listening to, Rush to Glory.
Oh yeah,
That
yeah.
was the
We're coming in second is never good enough.
but Ross Braun he's later than that. So that was the 76 championship. Ross Braun started in the very late 70s
Do you follow that sport?
and did most of his work in the 90s and 2000s. Yeah, yep.
You're a NASCAR guy too?
I do.
Have you been to?
No, not really. I have been to neither. Well, actually, let me take that back. I have technically been to a NASCAR race, but I didn't see any of it because I was working for my high school track team. We were manning a concession stand for a fundraiser. And so I heard it.
Yeah, yeah, yeah.
but I
Me too.
didn't
That's how
see
I
any
did
of the
it,
race.
right? It was so loud and kind of scary, right? But did you know that
What
can
track did you go to?
Meadows or wherever that was in the Speedway over here by
Oh, you went to
Downton
a race
Beach?
here. Yeah.
Yeah. It was I think it was a NASCAR, or no, it couldn't have been a NASCAR. Maybe it was stock cars. I don't know. It was really loud, just like you said. Yeah, really loud and kind of like intimidatingly loud. And like I can imagine being
Yeah,
a fan sitting in those crowds and being like, Tiger, right? Flying off and coming
yeah.
into the crowd. That's what I envision.
Well, that's why they got those giant fences.
Yeah.
You
Do
see
you know?
some clips of. Oh, go ahead.
I think you can drive a race car. Like they have these like experiences that you can this experiential life things, and you can actually drive a race car on that track.
Yeah,
Oh,
and they've got driving schools and stuff too. The cart, the go-kart club that I'm a part of also has a road race
oh
where you
shit,
can
you're in a go-kart club?
go-kart on the track.
Oh man, so many things. Why wasn't that in the bio? Was it?
It's in my I mentioned karting in my bio.
Did you? Hi,
Yeah,
Stephen. Good
it's like
morning.
a throwaway line at the end.
Yo,
You're looking more and more like your comic book characters, or are they looking more and more like you?
I think it's my art is a reflection of me. That's
Oh,
how
gotcha. Good for you. Well, good morning. So so today, Stephen, I think Bryson and I talked, we would like have everybody mute their mics so that we don't get that steal the screen
yeah.
pitch, and then also when we record, can we go back and forth between gallery and speaker view, and is that how that records then?
How do you have do you have it recording for let me look at it. Do you have it recording for multiple views?
I don't know how to do that. If that was,
I have to.
you're a co-host now, so you can make it
Well,
happen.
this will
Bryson.
be on the recording, like the recording section. One second, let me this is something like you have to go on like the actual website and change. Let me,
Oh, can you go on there?
yeah. Let's see.
So Bryson, are you guys going to do a wedding dance?
Probably. We haven't figured out what song or anything yet. We actually still haven't even figured out the DJ.
Hmm. So what we'll do is I'll try to keep Bryson on as a spotlight, and so we'll see how that works.
Okay.
Because I am trying to. Let me see if I could. Like I'm trying to. Zoom plugin.
So I've got a thing I've got to do at 11. But this
Okay.
presentation, I realized doing it should be shorter than the one from 2 weeks ago. So it shouldn't be an issue.
Okay, cool. Yeah, so we'll see the I have you on spotlight right now, and so hopefully with you being on spotlight it should keep it. And then I think I'll have to go into the settings, and what you can do is you can record it. You can record gallery view, spotlight view, like gallery view, spotlight view separately, and then just the speaker and the share screen separately. So like there's a way to share, like do all that separately. Yeah, so I'll have to play with some of the settings after this. But we should be, essentially, we should be golden right now.
Okay. I have 3 people in the waiting room.
All right.
Can I let some of them in?
Yeah, I think
Okay.
and you know you're already recording, right?
Well, I don't, but you're recording.
Good morning.
Good morning.
Good
Hello.
morning. This is Katie Booker.
Oh, hi, Katie. How are you doing?
Good morning. So good to hear your voice. Fawn,
Oh,
is that you?
Yes, honey. Yes.
Excellent.
Welcome.
Happy New Year. Thank you very
Oh
much.
my God, Happy New Year and spring and St. Patrick's Day and Valentine's Day.
Thank you for everything, and thanks for inviting me.
Oh, of course. Our #1 fan. It's good to hear your voice too. Are you calling
Thank
us
you.
from the Beaverton?
No, I'm here in Portland.
Oh, in Portland. Okay, good. Wonderful.
Yeah.
All right. And and you know, if we'd love to see your face, so if you're able, show your video. If not, that's good. That's okay too.
Okay.
Welcome,
I'll
everybody.
just be doing. Thank you. I'll just be doing the audio.
Sure. Okay. And then it looks like
Thank
we
you.
also have Mims Rouse that joined us. Welcome, Mims. And then
Hello, Fawn.
how are you?
I am well. Thank you for
That's-
asking. How about you?
Good. We are long overdue for a check-in, but thanks for joining us for today's episode of our Business Basics series. I think it'll be good for anybody who's looking to get their business financed or might have to work with partners, which I know that you do, Mims, so that's good. And then I see another, it just says a phone number, 503-475-1977. Who's this?
That's me.
Oh, that's you, Katie?
That's Katie.
Okay.
Yes, that's Katie. Mhm.
Oh, the other one is, it's Jonelle. Hello, Jonelle. How are you doing today?
It's-
That's the other one. Welcome, Jonelle. Can we hear you? Did you want to say anything? Okay. Well, Stephen, I'll let you, give the ground rules about the muting and anything that you want to do, and we can take off from here. Welcome.
Okay. Yeah, let me wonder if I can remove the spotlight first. And I will put myself on the spotlight. And yeah, so welcome everybody. Thank you for joining us for another episode of the Business Basics series, sponsored by the Soul District Business Association and Sussman and Shank, and also being produced by Flossin Media. Before we all get started, make sure to mute your mics so that it doesn't give us any feedback, and it doesn't mess up the recording when we are when people are asking questions, stuff like that. So that's just one note. We'll be recording this, so it will be available at the probably later on today or tomorrow once the recording is finished, and it will be available on the website. And so we'll go ahead and have a few more people join, and we'll just mute their stuff. Okay, so for this is an ongoing business navigation and education series designed to help small business owners with the challenges of operating successful and profitable businesses. And I'm your host, I'm your moderator, Stephen Christian. I'm a local business owner as well. And so I know exactly what you all will be going through because I'm currently going through it as well. Today's presentation will last around, 60 minutes with time for public comment and discussion at the end. If you have any questions throughout the presentation, please be sure to add them into the chat. And the chat button should be at the bottom if you're on a desktop or a laptop. And we'll be able to address those questions and comments and concerns when we get to them. Today's topic is working with the business partners and legal issues associated with financing your business. and is led by an expert presenter, Bryson Davis, who was an attorney at Sussman and Shank LLP. And Bryson regularly serves with the wide-ranging legal needs of businesses and nonprofits of all sizes and industries. Bryson's practice involves advising and representing for-profit and nonprofit clients in a broad range of business issues from formation to sale, and he often serves as external general counsel for his clients. His practice touches on mergers and acquisitions, business formation and maintenance, security offerings and sales, real estate transactions, contract drafting, employment advice, and regulatory compliance. In addition, he has specialized knowledge helping clients in the cannabis industry, working with professional licensing issues and handling administrative law matters. In addition to his legal practice, Bryson is committed to improving social and economic equity across the Northwest BIPOC communities. This commitment has led to Bryson's participation and leadership within several nonprofit organizations and community groups whose mission and purpose is focused on increasing equity, supporting diverse representation, and economic development. So, do me a great favor of welcoming Bryson. And for you, Bryson, go ahead and take it away.
Ooh, yay! Welcome.
Thank you, Stephen. All right. And welcome, everybody. So I'm going to go ahead and share my screen. All right. So today we're going to be talking about financing your business and working with business partners. I'm going to be making some references to my presentation from 2 weeks ago. And so if there are questions that people have regarding those topics, you feel free to reach me after, and I can help walk you through those, or you can check out the previous video. But today we're going to be mainly focused on bringing in money for your business and managing and navigating working with other owners. So we'll start with financing. So the first type of financing that people, and the main go-to and the thing that people normally think about when they think about financing their business is financing it through debt. This is borrowing money from various different types of places in order to pay for things in the near term, and then paying that debt back over time. The first type of debt that people will take out when they're starting a business is they'll do some sort of personal debt. This is somebody is using their personal credit card. They take out a personal loan. They borrow money from their friends and family. This is the most common way that people do take out debt to start a business. When people do that, we talked in the last presentation about maintaining your liability protection when you're running your company, especially when you have an LLC, and keeping your personal finances separate from your business finances. So when you as a business owner use your money that you've borrowed from someplace else to help finance your business, make sure that you're documenting the money that you borrow and are using as a contribution from you to the company, or as a subsequent loan from you to the company. That way it's not, you don't run into a case of you taking your funds and buying company assets with your funds. There's a documented separation between where your assets start and stop and the company's assets start and stop. Now, friends and family can often have the option to lend to you directly or lend to the company. Typically, you as the business owner will prefer that they lend to the company. That that makes it so that if something goes wrong, something goes under, then their ability to any lender, whether it's your friends or family or a bank or whatever, they're lending to the company, and the company is well established, and you have a proper your liability shield in place. Any debt, any ability to recover stops at the company's assets, and so if you're not going well and your business goes under and you only have $10,000 worth of assets and you have $15,000 worth of debt, if everybody has lent to the company and you've done everything right, then you'll pay back the 10,000 to $15,000 of debt, and then the lenders will be basically on the hook to eat the 5,000. If on the other hand, you haven't done things right, things aren't separated, or you took out the loan personally, then that extra $5,000 will be coming out of your pocket, or may come from the sale of your personal assets, and could follow you much longer. And so you as the business owner always prefer, when you have a legal entity set up that has liability protection, that loans go to the company. That being said, your friends and family, when they lend to you, have the exact opposite preference. They'd prefer to lend to you, because then even if you don't make it, you're still on the hook for paying them back. And so in a lot of these cases, the things that protect you as a business owner will often be counter to the interests of the people lending you the money. Likely, if you are starting a brand new company, this is the first time running the company, you don't have any operating history, especially if you don't have a lot of assets. You'll potentially need to personally guarantee the debt if you take out loans from a sophisticated lender. One thing to be aware of is some easy to get online loans, and some loans from companies such as your point of sale service provider, and companies like that. Beware of those, because sometimes those terms aren't as favorable as you could get from nonprofit lenders or from traditional lenders, or from friends and family. And sometimes those loans also come, especially the ones that can tap, like from point of sale service providers that can tap directly into your revenue stream. They could limit your flexibility on repayment, and limit your revenue in a way that makes it difficult for you to grow your business. So nonprofit lending. Now there are several different nonprofits and several different types of nonprofits that provide lending to companies. Even with nonprofits, though, finding loans for a brand new startup business is still hard to find. There are a few nonprofits that do it. Mercy Corps, for instance, is one that people particularly like, that has a startup lending program. Typically, nonprofits like to see at least that you've been in business for a year in your current line. And of the nonprofits that lend to businesses that have been in operation for a year, you've got several choices of CDFIs, which is Community Development Financial Institutions, that do a broad range of scales for loans, everything from micro loans. BISO does really small loans, to middle-sized loans, around your $50,000 to $250,000. MISO does that. Craft Free does some of that. Community Lending Works can do some of that. To your larger loans, Craft Free does larger loans. And so nonprofit lenders have a pretty broad range, and they also have a broader range and a higher risk tolerance than your traditional banks or your traditional credit unions, as the nonprofit lenders don't have to make a profit, and they typically have some sort of mission that they're serving, on top of the just transaction of lending. So banks and credit unions, despite nonprofits being a good way to kind of get into the lending space, if maybe you struggle to qualify with a bank or a credit union, banks and credit unions typically will give you the best rates. Though, as I just mentioned, these lenders will also be willing to take the least amount of risk. And they're often the least forgiving and least flexible if you start struggling to repay the loan. Some banks may even package your loan and sell it off to other banks as part of a packaged debt security. And so banks and credit unions are really good for established, well-run businesses that have a pattern and know what they're doing and things like that, and don't have serious concerns about potential down the road repayment issues, or kind of shaky business operations that they haven't quite got a hold of. Banks and credit unions are great choices for those companies. For other earlier stage companies or newer companies or companies where the owners are still kind of getting in the flow of debt management, nonprofit lenders and private lenders can be a better choice. And so there are other private lenders. There are private individuals who they will build their own business lending portfolio. They may be just a wealthy individual who's looking to diversify their investments, or they may be another company in the same industry. They can be hard to find if you don't have the right connections. A lot of times the private lenders, if you're not going through some sort of peer-to-peer lending club, or some relatively large established group of private lenders, a lot of times these are basically, they're very similar to friends and family in your relationship to these people. But they do exist, and they are out there. So equity is the other type of financing that businesses typically use in order to get money to run the company. So what is equity financing? So this is typically you bring in a business partner, another business owner. Sometimes they're passive in that they don't manage the company. They're not doing any work for the company. They're just putting money in. Sometimes they're active. Sometimes they play a management role in the company in exchange for their equity contribution. But they're basically buying an ownership share in the company, and they become an owner along with you in running the company. So the mechanics of this is this investor will provide money as a contribution, also called an equity investment, and then they own that part of the company that corresponds with the amount of money that they put in. If you value the company at $100,000, they put in $90,000. Typically, they'll own 90% of the company, as a very basic way of looking at it. Them having ownership typically entitles them to a share of the profits of the company, and then when companies are liquidated or sold, they're entitled to their share of the proceeds from the sale or from the liquidation. Some investors may require some management control, and especially again with earlier companies, there's securities issues which we'll talk about later, but also investors who maybe don't have a lot of experience with a new company may want to have some control so that they know that they can step in if things start going south. Be conscious of your investors' understanding. So there are many people out there who like the sound of being an owner of a company instead of being an employee of the company, or instead of being a lender of the company. But there are a bunch of considerations that some people don't necessarily take into account when they're doing this calculation of whether or not to be in sort of an employee or contractor role. or being a lender role versus being an equity owner of the company. Being an equity owner means that your monthly income from the business is dependent on the revenue and the profits that the business is making. If you're an employee of the company, or you're a contractor of the company, or a lender to the company, typically your payment is scheduled out so that your payments are consistent each month, based either on the work that you did, or based on the repayment schedule for the loan. And so for people who need consistent regular income each month, being in the position of being an employee, or being a contractor, or being a lender, where the revenue from the work that you did, or the debt that you provided to the company is consistent each month, might be more attractive. And making sure as you look for equity partners in your business, that they understand the difference between the cash flow of an employee, contractor, or lender versus the cash flow of an owner, and making sure that they have appropriate expectations for their cash flow based on your current business operations. A misunderstanding here could really lead to conflict down the road, which could lead to friction, which could cause all sorts of issues with how you run your business, especially since this person now owns a piece of it. And then there's securities. This is dealing with business owners who they just want to give you money and then have you build the company, and then maybe they sell their stake in the company, or maybe they just sit back and collect the profits. And these are people who aren't interested in working for the company. They're interested in just giving you money and having them get a return. If you want to avoid providing somebody with management control, but you still want to take their money in terms of equity, which has fewer repayment requirements and timeline restrictions than debt does, this may be a way to go. That being said, often for smaller companies, this is something that you want to avoid. And the key way to avoid it is providing that person with management control. Securities laws compliance is very complicated, very expensive, and one of the major reasons that companies will typically prefer debt financing over equity financing. So let's talk a little about working with business partners. So let's get some kind of terms out of the way. So as a business owner, you'll hear several different types of terms related to business owners. A member is an owner of an LLC. Some members may also be called managers, and managers basically serve as in a similar role as officers of a corporation. You have partners, which are owners of a partnership. This could be a general partnership, or a limited partnership, or a limited liability partnership, like we discussed in the last presentation. And within partners, you'll have limited partners and general partners. General partners are joint and severally liable for the liabilities of the company, of the partnership. Limited partners are shielded from that liability. And typically, if you've got in sophisticated partnership structures, if you have a general partner, then the general partner is often some other entity that has liability protection, such as an LLC or a corporation. A shareholder is an owner of a corporation. They own shares in the corporation, shares of stock. You'll have voting shareholders who have a say in the various management decisions, the who's on the board of directors, things like that. And you'll have non-voting shareholders who are effectively just passive investors who don't have a vote on various corporate issues. It looks like Mims has raised his hand. Mims, what's your question?
Well, I wanted to know, and kind of going back to something you mentioned earlier. So if, let's say, a brother loaned you money to get the business started, and that money was, let's say, reflected the bulk of the funds needed to get it going. And your understanding was that your brother's loaning you that money personally, but there's nothing in writing. And so you start the business and things are going along, and then all of a sudden you land this huge contract, and they say, we're gonna be rich. And so are there things to avoid a misunderstanding where your interpretation is that that money is being loaned to you personally so that you can invest in the business?
Yeah, so there's several things that you can have here to sort of avoid conflicts in that sort of arena. The number one, and I can't stress this enough, and this is I talked about it in the previous presentation, and is the number one practice that every business owner should do, and that is write down and document your agreements with other people. So that's the first key, because if you do that, then you'll say, all right, you'll have all the terms laid out. So you'll know that this person is loaning you personally money, and they are expecting X% interest rate and X schedule of payments. If you write that down, then everybody can sort of follow that trajectory, and their repayment won't be based on your future success. And it helps clarify that they are loaning you money, they're not investing in your business. If for some reason you have forgotten to write it down, or the transaction happened, before you realized that you needed to write it down, that sort of thing, then what you should do is go back and write it down before you get to major inflection points, major potential conflict points. Even something as simple as sending them an email saying, you lent me this amount of money. This is my understanding of the terms. This is my understanding of that it was a loan, that you weren't buying into the business. Sending that out, having them acknowledge it, that can also be good document for what people owe to each other. If you kind of get to the point where you've gone past the point where you can't document it before you run into to a potential problem, that's when you can get into expensive conflicts, depending on how much the loan was for, and depending on what everybody's understanding of it is. Oftentimes, if you've got someone lending you money, it can be treated as a loan if it's being repaid regularly, and you're not recording that person as an owner of the business. One very good way to kind of shut down potential claims from that person, if you get into a situation where, say, you got a large contract, that contract had enough money and enough upfront payment, paying that person off completely can be a way to put them in a situation where it'll be difficult for them to cause a lot of issues. But I think the key takeaway from any of those types of scenarios is write things down, document them. And if people that you're working with are hesitant or not willing to write things down and document them, then they're probably not the type of people that you're going to want to be doing business with, because they're the type of people who can cause increased problems and problems that are more expensive down the line if there's friction between you and them. All right. So the next piece. So your basic considerations when you're working with other people, and these are other owners, is the first is ownership percentages. How much does each person own? How much money is each person expected to contribute when they buy into the business? Sometimes people are contributing all of their contribution in cash up front. Sometimes people contribute money in over time with a promissory note that functions sort of like a loan. Um, and so the mechanics of that are things you have to work out. And then how much of the profits of the business do the owners get as a whole versus reinvestment into the company, and how much of those profits does each person who invested get? So those are one things that they have to consider. Second is decision making, your voting, and your authority of the various owners. So what kinds of decisions, purchases, contractual commitments can each person make without the other owners weighing in? Sometimes if you have in a situation with an LLC, for instance, and you have say 3 members, but one person is designated as the day-to-day manager of the business, they might have more of an ability to make decisions, make purchases without the others weighing in. If you've got an LLC, for instance, where you're all members of the LLC, you might all very major issues that impact the company. You might want to have everybody at least be aware of, if not have a vote. And then when you have that vote, there's a question of what's the threshold that needs to be met in order for the company to be able to take action. Is this something that just a majority of owners needs to approve? Is this something that maybe more than a majority of owners need to approve? Is this something that everybody needs to agree on in order for it to happen? Some examples are, you might have a purchase that might just be something that you have a majority of owners needing to agree on it. So if you're going to make a significant purchase, you run it to the ownership. The owners say, yes, we agree. If at least 50% plus a little bit agree to make the purchase, then you can make that purchase. Something where, like for instance, adding a new owner to the business often requires a higher threshold than 50%, because people want some security that the people they're going to be working with are people that they can work with. And so sometimes you might even have all the way up to all of the owners have to agree before we admit a new owner into the business. And so that is something that needs to be determined up front with your business partners and the other owners in order to kind of have smooth operation of the business going forward. That's not to say that it can't be changed, but determining it and setting it out up front, again, setting it out in writing, helps to avoid the down the road conflicts, and the down the road conflicts that can be more expensive rather than the easier disputes that have clear resolutions. And then sort of what's each person's authority to bind the company. So, do you have the ability to commit the company to a cell phone contract? Do you have the ability to commit the company to a contract with your point of sale service provider? Do you have the ability to commit the company to an independent contractor agreement? All of those sorts of things. You want to lay out each person's authority and what they can and can't bind the company to. This will this may not completely shield you from somebody running off and making a decision that everybody else doesn't agree with, but it may provide you an easy and clear way to recover from that person if their actions cause damage to the company. And then the last thing is setting out the management tasks. You've got, there's the ownership of the business, and then there is what people have to do day to day to make sure that the business generates revenue. Who's making sales, who is out there, actually doing contracted work, who is dealing with employee issues, all of those things, all those management tasks you'll want to lay out at the front ends, so that everybody knows what they're responsible for. Some contingency considerations that you'll have working with business owners deal with issues that come up where that can cause friction between owners, or could cause a reason to buy owners out. So one very common thing, and it happens to many business owners who get into business. They get into business with friends or former colleagues, and you start the business and everybody's happy, everybody's on the same page, everybody's working towards the same goal, and then you get to a point in running your business where one owner wants to do one thing and the other owner wants to do another thing, and you're at a point where you can't agree on which way to go. This can lead to the production of the business kind of grinding to a halt while the business owners sort this out, especially if you have a business that has an ownership split of 50-50, where you will effectively need the owners to agree on what they're doing before things can get done. Typically, to avoid this, I often recommend having one of the owners be a majority owner. So if there is some sort of irreconcilable difference, one owner becomes the default manager, can make the decisions going forward while the two work out their issues, or negotiate some sort of buyout. I had a client that had an internet marketing company, and they did this where one was a 51% owner and one was a 49% owner. And when they hit friction between the two of them to the point where they couldn't agree on where to go, the 51% owner took control of the company while a buyout was being negotiated between the two owners, and that helps the company continue to operate, continue to generate revenue, and so you don't end up with a situation where your business is going dormant, or maybe even dying because the owners are fighting. The business is able to keep functioning and still generate revenue and profits for all of the owners. And then another thing is to, in upfront, and this you'll do in your organizational documents, your operating agreements, your shareholder agreements, things like that, is predetermine a procedure for resolution of these types of conflicts. If you run into this issue, predetermine that one owner has the ability to buy out the other owner, that kind of thing. So that if this comes up, you're not sitting there in a protracted litigation fight between owners. You can get right to the mechanisms of the mechanics of the contract and say, all right, we can agree. That means I have the ability to offer you X price for your shares according to this valuation formula that we set up, and I can buy you out according to these terms. And so predetermining that procedure can help smooth over the potential conflict in the event that you have owners that disagree. Buy, sell, and right of first refusal provisions are good good mechanics for that situation, and they're also just kind of good for other buyout situations. So these provisions will determine a formula for the buyout price, and so it can help prevent protracted negotiations about how much someone's ownership is worth, which especially for privately held companies can be complicated and difficult to evaluate. And then right of first refusal provisions can allow current owners the ability to buy an owner's share who's stepping away for whatever reason, and sort of prevent that owner from being able to sell their shares to somebody who the other owners may or may not know, may or may not be comfortable working with. The right of first refusal kind of gives the other owners the control over the other who is an owner of the business. So retirement and death are both situations where people lose their shares, or no longer work in the company. Oftentimes, a good operating agreement will have share sale provisions and right of first refusal provisions that apply to retirement and apply to the death of an owner. That will help make it really mechanical how you go through that process. Companies will also hold life insurance on particular key owners, and that will help fund those buyout provisions in the event that an owner dies unexpectedly, and can be a very good source of funds for that mechanic. And another piece that can be structured into the organizational documents is having heirs of someone who's died, or someone who's passed their economic interest on to their children or something, have an economic interest in the company, but not necessarily management control in the company. Divorce and bankruptcy is another contingency that you'll want to consider, because both can end up with somebody who is potentially somebody that the other owners very much do not want to have to work with as a co-owner, forcing their way into controlling the company. Good organizational documents will put in provisions that in the event a divorce occurs or a bankruptcy occurs, the status of the shares changes from management control ownership to an economic interest, or it triggers a buyout, or it triggers a right of first refusal. Something to prevent unwanted owners from taking the owner who goes through that divorce, goes through that bankruptcy's shares. And then some advanced considerations are your tax classification. Is, given how people are working and operating business, is an S corporation or a partnership taxation structure better for you? Your tax allocation. It might make sense for one owner to be assigned a bunch of losses, and one owner to be assigned profits. How that allocation works will depend on the financial situation of various owners. And then kind of guaranteed payments and S corporation dividends, and effectively employee compensation for various owners. There are multiple ways to do it. Each entity structure has some quirks and mechanics that can adjust, especially the taxing structure of how these work. You'll want to work with your CPA to say, all right, this is our revenue, this is our situation as owners, what's going to make the most financial sense for us, given that. So securities, I mentioned it briefly when I talked about equity financing. Securities are a thing that most small business owners want to avoid, but they can be a good tool for more sophisticated companies when it comes to raising money raising money for their business expansion. So what is a security? So this is stock in a corporation. It is also what's called an investment contract, which is where somebody is giving money to a company with the expectation of generating some sort of investment return through the work uh, of others. So the person who is investing money into the company is not doing work for the company. And this is also kind of not a predetermined scheduled payment like a loan. This is, I gave you $10,000 and I expect to get the profits from owning 10% of your company. This is along those lines. Some interests can go either way as to whether or not they're considered a security. Being an owner of an LLC sometimes is a security, sometimes is not. If you're a manager for the LLC, that often makes it so it's not a security. If you're a passive investor and you don't have any management control over the LLC, you've just given your money to the LLC, then in that case, you probably did buy a security. Other things such as co-tenancy interests, fractional interest in real estate, the Howey test that's mentioned on the slide. You bought an orange grove that came with a management contract, and so there's all sorts of things that can blur the line between what's a security and what's not a security. And don't normally seem like a security in the traditional sense of being stock in a corporation, but effectively the person putting money in has very little control, if any control, over how the business is being run and how the profits are being generated. And when that's the case, you're typically dealing with security. So the reason you have securities laws and securities regulations are to prevent fraud from being perpetrated on people, give people full disclosure of the business that they're getting into, so that they know what sort of issues they're getting into. Fawn, it looks like you've got your hand raised.
I do. I wonder if this falls into this category. I know sometimes businesses start as one thing and then they kind of evolve, and sometimes another aspect of the business can also pop up as profitable. For example, if I had a aquaculture shrimp, if I was raising fish, right? I had a fish farm, a shrimp farm, right? And I'm selling shrimp and I'm raising shrimp. Well, then it turns out like, hey, the shells of this shrimp can be used as suture material for medical equipment, right? And they make like stitches out of it, suture and stuff. And that part of the business takes on a whole revenue aspect of its own. How do I ensure that my original investment or my partnership in the root business also, what do you have to do as partners to prevent, a new thing that emerges from your business that could, does that offshoot into a different business? And what kind of notice do they have to give you about that?
So if you're taking one line of business and kind of spinning it off into another, the easiest way to do that is to form some sort of subsidiary company that runs that and manages that business that your normal company owns. That's usually the easiest way to do it. Sometimes, if it's related enough, you might just have the main company just have a different department and operate two lines of businesses. But the key thing is, for stuff that comes from your business, your business partners, again, with well-drafted organizational documents, will be tied into not being able to take chunks of the business and go and do their own thing with them. They will have to those sorts of business decisions will have to be made through the structure, through the management structure of the company.
So we
And
should
so
there be
it-
a subsidiary clause in things like this then?
you don't necessarily need some sort of clause designating that new lines of businesses will be spun off as a subsidiary, because it doesn't always make sense. But the organizational documents will basically spell out the ownership of assets and lines of business for the company. And so spin-offs like that will still be owned by the company and still subject to the company's management structure. All right, so legal requirements with securities. You've got to, the default is that you've got to register them. That's incredibly expensive. Most small businesses never get to that point. There are many exemptions from registration. What's called private placements, things like that. If you're going that route, you're going to want an attorney to help guide you through all of that to make sure you don't mess it up. It's very complicated, very difficult to find a lot of this regulation on your own. If you're doing private placements, there's a lot of restrictions on how you can offer, how you can present the opportunity to buy the securities. You've got what's called accredited investors, which are people with a certain income and certain net worth. Those types of people are much easier and have fewer restrictions on selling securities to. If you're just selling to a random person who, maybe has $40,000 of income and maybe only has a net worth of $50,000 or $60,000, there's lots of restrictions, lots of protections in place to prevent fraud for that person, and a lot of extra hoops that you've got to jump through. Typically, it's not worth it to sell to those types of investors because of the regulations, except through public offerings, which again are for much larger companies and companies that are much better capitalized. And then all of the security stuff really requires lots of notices with the state and with the federal government, and they require lots of really full disclosure to your potential investors, especially with regard to the finances of the company. And so with that disclosure, I mean, it's really everything that you'd want to know when purchasing an ownership interest: financial statements, financial status, potential lawsuits or investigations, potential claims for product liability. You'll want to give a reasonable projection of the company's financial history, but you want to be very careful about that to make sure that you're not too optimistic. You'll want to make sure you work in the risks of that industry, the risk of working and selling products or providing services where the company operates. And pretty much kind of anything that's relevant to the company's bottom line, you'll need to lay out in a big disclosure document in order to go this route. So liability. So some securities transactions will require some sort of escrow of funds to either to not collect until the offering is completed, or keeping some money in reserve in case something goes south, so that the investors have at least some sort of pool of potential repayment. And then now as a business owner, you'll as you operate and get experience, you'll realize that some laws and some regulations, if you violate, the governing agency will maybe just send you a letter, give you the opportunity to correct what you're doing, that kind of thing. Some things are more serious and may have built-in fairly punitive fines. Securities laws are in the much more punitive range of laws if you violate. How serious are the consequences? You might need to repay an investor's entire investment. You might have penalties. You could be facing jail time if you violate certain securities laws, or create certain liability from what's deemed to be securities fraud. Um, and the liability for filing securities issues can extend beyond just you as the business owner and beyond just the company to anybody who helped you sell the security. So if you get busted for securities fraud because you've been selling it to let's say people at your church, if you had your friend Jim, who's not an owner of the company, going out and getting people interested in buying shares in your company, Jim could also be liable for securities fraud if that's found to be the case. And so liability is pretty broad-reaching. It's very punitive, and it's again something you're going to really be careful of. So last thing is get professional assistance, especially as you get into the more complicated arenas. So CPA for all of your tax consequences. If you have multiple owners, or you have, or you're dealing with securities issues, or you have debt considerations, CPAs can help you kind of figure out how all of that works with the taxes for the owners, and how all of that can be best managed in terms of your revenue versus your costs. You could be paying, if you're in the wrong tax structure, you could be paying more in tax than you need to be paying. One common thing is people realizing that they can pay significantly less in tax if they're taxed as an S corporation versus being taxed as a partnership. But a CPA is going to help you go through your finances to help you determine what the best entity and taxing structure and things like that are for your business. Attorneys are really key to getting those organizational documents nailed down up front to help provide the mechanics for the management of the company for multiple owners. So this is, as I mentioned earlier, buy-sell provisions, your operating agreements, your what happens in the instance of a death or retirement, or if there's irreconcilable differences. Attorneys are very good at laying those out up front so that you've got a roadmap. And so if you hit an issue, you hopefully won't have to pay a different attorney a lot more money to deal some sort of litigation dispute. Attorneys can also help you navigate the myriad of securities issues if you're bringing on new equity owners. And then CPAs and attorneys are good for helping you evaluate loans. CPAs from the financial side, does this make sense with the financial flow of your business? Attorneys can help you review and understand the lending documents and also the restrictions on what you can do as your company with your company while you have outstanding debt. Attorneys can also help you document your loans to friends and family. If your friend's gonna lend you $10,000 to start your business, hiring an attorney to get that documented in a loan can be a good investment to make sure that you're not running into a situation like Mims described earlier, where people expect an equity interest when really what they have is a debt interest. All right. Are there any other questions about what I covered today? Okay. Hearing none. Thank you for your time. My email is on this screen. If you have any further questions, feel free to reach out to me. I'd be happy to chat with you about your situation, figure out what you need to do, what considerations you may need to make. If you would like help finding potential lenders, things like that, also let me know. I can help give you some guidance or point you in the direction of people who can.
Okay.
Yeah. Thank you very much, Bryson, for giving us that valuable knowledge and everything. And before we let you all go, make sure to put on your calendar. So this Business Basics series happens every 2 weeks, and it's going to be on Mondays. So it's going to be 2 weeks from now on Monday at 10 a.m. And so you could go to the Seoul District Business Association website event page to look at the schedule. And if you're listening to this presentation again, we'll be able to feel free to share it with others, and it'll be available on Flossom Media's TV YouTube channel. And also it's going to be on the Seoul District Business Association website, which is www.seouldistrictbiz.org. And if you have any other questions about the series or any ideas, feel free to contact them at 503-841-5032. And so again, I appreciate Bryson for his valuable time and the lovely information that he presented to us. And if there's any other questions, be sure to reach out to us.
Stephen, I just want to correct. So the schedule is on the Seoul District Business Association's Facebook page. It's updated on the Facebook page.
Okay.
That's the best way to get real-time information on that, okay?
Okay, yeah. So head over to the Seoul District Business Association Facebook page, and that will give you all the information that you need.
Thanks, everybody. It's good to see you.
Thank you.
Or hear you.